Good afternoon, fellow colleagues. Today I thought we could have a little chat during our lunch break about some of the proposed reforms that are being introduced for the Retail Shop Lease Amendment Act 2016. I thought this would be a good opportunity to discuss some of the advantages and disadvantages that are going to be in the amending legislation. The Retail Shop Lease Amendment Act was passed by the Queensland Government on May 10th. The bill is the result of a review by major stakeholders which sought to improve the Act's efficiency and effectiveness. It also seeks to reduce red tape and compliance costs. It also seeks to address imbalances in access to information and negotiating power without unduly interfering with commercial arrangements, whilst also aligning Queensland's legislation with key eastern seaboard states to enhance operation efficiency and legal certainty for stakeholders operating across jurisdictions. Now, there has been some significant changes to the Act. I would regard these as disadvantages, as the Act now no longer applies to retail shops with a floor area of more than 1,000 square metres. Also, ATMs, vending machines, advertising displays, storage and packing areas in common areas of a retail shopping centre are no longer covered. Premises are not used wholly or predominantly for carrying a retail business and no longer covered, whilst the Act amends the calculation of when a retail lease is entered into. Also, for government leases, the requirement to provide disclosure statements, legal or financial reports, or receive notice of when an option needs to be exercised have also been removed. Now, there is a lot more advantages, however, to this reform. Landlords will be required to give a current disclosure statement to a tenant within 7 days of the exercise of an option. The tenant then has a further 14-day period to withdraw the option exercise notice. If it is not given or is defective, the tenant has a right to terminate the option lease within 6 months. This will be under Section 21B. Landlords will also be required to give updated disclosure statements to a tenant who wishes to sublease under Section 21C. Landlords will need to make available to tenants a marketing plan detailing their proposed advertising and promotion expenditure. This will be a new Section 40A. An audited statement of landlord promotion expenditure must be given to tenants within 3 months after the end of each ancestry period, under Section 41, Insert 4. Now, also there is a fair few more advantages. A leasee franchisor may request an up-to-date disclosure statement from the leaseor to provide to a proposed franchisee, but the franchisor will be responsible for the lease's reasonable costs of doing so. Where market rent is to be determined by a specialist retail valuer, new provisions have been inserted to help the parties to properly make submissions to the valuer. The bill also introduces the concept of the calculation of rent on an effective rent basis under Section 145. There were greater restrictions on the outgoing the lessor can charge, and the lessor must now provide a marketing plan to the leasee at least 1 month before the start of each accounting period if the leasee is required to pay a marketing levy, and provide an annual audited statement of its expenditure for promotion within 3 months after the end of each accounting period. This will fall under Section 148. Now, tenants will also only be required to refurbish retail shop premises during the lease term when the lease gives sufficient details of the nature, extent and timing of the refurbish requirements, and this will be under Section 50B. Landlords will be made liable for the cost of obtaining consent from a mortgage and the cost of complying with the Act. Any unspent funds will also be carried forward to the next accounting period. There is an ability for the intention to waive the 7-day disclosure period, and landlords will also be able to recover lease preparation costs where the tenant has negotiated but does not wish to proceed with the final lease after instructing it to be prepared. This will come under Section 48, Insert Section 3. Landlords will also no longer be liable to compensate tenants for business disruption where the landlord's action is a reasonable response to an emergency. This will be Section 43AB, Section A. Compensation to tenants will be able to be limited for anticipated disruptions to business that occur within 1 year of entering into the lease, provided required details are given before the lease is entered into. Tenants will have a simplified process for waiving disclosure periods and mandatory rent provisions. Procedural requirements are to be relaxed where the state, Commonwealth or a local government is the tenant also. Now, these are just some of the advantages and disadvantages of the reform to the amendment bill. I hope you've enjoyed them and I look forward to your feedback on them. Thank you.